Starting this July, three massive regulatory changes are quietly landing on America's seniors, and every single one of them is engineered to pull money straight out of your pocket. Not next year, not someday down the line, but right now, this very month. One of these changes allows the federal government to slice into your Social Security check before it ever hits your bank account. Another grants the bureaucracy the power to reach in and hold back half of your entire monthly benefit, even when the underlying mistake was never yours to begin with. And the third change, the one that almost nobody in the mainstream media is talking about, is quietly dismantling the nutritional assistance that millions of older Americans depend on, just to put food on the table. What makes this implementation incredibly dangerous is that every single one of these policy shifts was deliberately written to happen in the background. You will not receive a letter in big bold print, you will not get a warning phone call, and you will not get a heads up from anyone at the local office. The system is designed for you to find out the hard way, specifically when your monthly direct deposit comes in significantly smaller than it is supposed to be. By the time you notice the discrepancy, the money is already gone, swallowed back up into the federal matrix. My name is Walter Barron. I am an estate and elder law attorney, and I have spent years sitting across the table from hardworking families who found out about these bureaucratic traps exactly 1 month too late. My job is simple. I read the fine print so you do not have to, and I break it down in plain, actionable English, so you know exactly what is changing and exactly what you can do about it. For all three of these major changes, there is a legal, established way to protect yourself, but you can only execute these strategies if you know what is coming. Whether you are 62 or 82, whether you are still working a part-time shift or are fully retired, at least one of these three structural changes is going to touch someone you love. Let us dive directly into the first major change, which is a massive regulatory shift. Beginning this July, the federal government has officially reactivated its aggressive collection apparatus to take money directly out of your Social Security check to pay off old, defaulted federal student loans. Now, I already know what a lot of you are thinking right now. You are thinking, Walter, I am 70 years old. I have not stepped foot in a classroom in 50 years, and I do not owe a dime in student debt. You might be completely right about your own education, but before you tune out, listen closely, because this specific policy is catching seniors completely off guard for two distinct reasons. The first reason is that this aggressive collection mechanism had been paused for years due to pandemic-era protections, meaning almost everyone forgot it was even legally possible. During the national emergency, the government hit the pause button on garnishing wages and benefits for defaulted federal student debt. That pause held for so long that millions of people assumed the debt had simply been forgiven or wiped off the books entirely. It did not disappear, it was sitting there in the federal database the entire time. And now the collection machine is being switched back on. The second reason this hits so hard is that it does not just target the people who took out loans for their own education. It targets grandparents and parents who co-signed financial aid paperwork, or who took out what are called Parent Plus loans to help a child or a grandchild get through college. The second you put your signature on that federal loan paperwork, the government treats it as your personal debt. If that child or grandchild struggles in the job market and defaults on that loan, your Social Security benefit is immediately put on the table as collateral to pay it back. This process runs through a highly coordinated system called the Treasury Offset Program, or TOP. When a federal student loan officially goes into default, which occurs after 270 days of non-payment, the Department of Education transfers the file to the Department of the Treasury. The Treasury can then garnish your Social Security Title II benefits, without ever needing a judge to sign off on a court order. They have the legal authority to seize up to 15% of your monthly benefit. While there is a legal guardrail stating they must leave you with at least $750 a month, that threshold has not been adjusted for modern lamb fat. If your monthly HUTRI check is $1,200, a 15% reduction means $180 is wiped out every single month before you ever see it. On a fixed retirement income, $180 is not a minor statistical adjustment. It is the utility bill. It is a week's worth of groceries. Or it is the medical copay for your prescription medication. Consider the reality of a 68-year-old retired woman living on a modest Social Security check. Years ago, she co-signed a loan so her grandson could afford college tuition. He hit a rough patch, the loan fell behind, and life moved on. She has not thought about that paperwork in over a decade. Then, Without warning, this July, her benefit check comes in nearly $200 short. She did not change anything in her life, but a bureaucratic switch was flipped in Washington. D. C. The Consumer Financial Protection Bureau estimates that roughly 450,000 Social Security recipients are exposed to this exact offset mechanism now that the collection pause has fully expired. The good news is that if you have a federal student loan, a Parent Plus loan, or a co-signed debt in default, you have powerful legal options to stop the Treasury offset program, but you must act before the check shrinks. Your first line of defense is applying for financial hardship relief directly through the U.S. Department of Education's Default Resolution Group. You have the right to demonstrate that losing 15% of your benefit would leave you completely unable to cover your basic, essential living expenses like housing, medicine, and food. Government data reveals that a staggering 82% of senior citizens currently facing Social Security garnishment for student loans actually meet the strict criteria to qualify for this hardship relief. The protection is sitting right there on the books, but the vast majority of seniors never claim it, simply because the government does not volunteer this information. Your second option is to pull the loan out of default entirely, which you can achieve through loan rehabilitation or loan consolidation. Loan rehabilitation requires you to enter into a written agreement to make 9 small, reasonable, and affordable consecutive monthly payments based directly on your disposable income, which can be as low as $5 a month for low-income seniors. Alternatively, you can opt for a direct consolidation loan, which combines your defaulted debt into a brand new active loan, pairing it with an income-driven repayment plan. This administrative process can completely clear your default status within 30 to 45 days, which immediately forces the Treasury offset program to drop the garnishment and restore your full monthly check. You can take control of this situation right now by calling the Treasury Offset Program interactive line at 1-800-304-3107 to verify your account status and initiate your hardship documentation. This brings us directly to the second massive change. And if the student loan mechanism makes you nervous, this one should cause you to sit up and pay very close attention, because it does not care whether you have ever borrowed a single dollar in your life. Starting right now, the Social Security Administration is enforcing a highly aggressive clawback policy to recover what they classify as an overpayment. An overpayment occurs when the agency reviews its historic ledger and decides that, at some point in the past, they paid you more benefit money than you were technically eligible to receive. This typically happens because your part-time wages fluctuated, your assets changed slightly, or an internal administrative form was processed late by their own staff. What makes beneficiaries absolutely furious is that the vast majority of these overpayments are not caused by applicant fraud or consumer error. They are caused by the Social Security Administration's own internal accounting mistakes, system glitches, and paperwork delays. Yet, even when the mistake is 100% their fault, they turn around and demand that you pay the money back. Historically, the agency handled these overpayment recoveries with a degree of moderation, typically withholding only about 10% of a senior's monthly check to gradually pay down the balance. While a 10% reduction hurts, most seniors on a fixed income can find a way to budget around it. However, that era of leniency has been replaced by a much harsher standard. The agency recently moved to reinstate a far more aggressive recovery rate, initially announcing they would withhold a staggering 100% of a senior's monthly check until the entire debt was cleared. Following intense public outcry and congressional scrutiny, they adjusted the standard withholding rate to 50%. Let that number sink in for a moment. Half of your entire monthly income can be legally withheld for months or even years to pay for an administrative math mistake that you did not make. For someone relying entirely on that who-try check to survive, a 50% drop is an immediate, catastrophic emergency. Government audits show that nearly 2 million Americans are currently sitting on the agency's overpayment hit list, representing a massive $23 billion in collective debt that the government is actively trying to claw back. If an overpayment notice lands in your mailbox, you must understand that you are not helpless, but you must act within the designated legal windows. The moment that letter is dated, you enter a critical 90-day window before the actual withholding begins. If you file an appeal within the first 30 days of receiving the notice, the Social Security Administration is legally required to pause all collection actions and keep sending your full check while they conduct an administrative review of your case. Your first move should be submitting Form SSA 561, which is the official request for reconsideration, if you believe their math is wrong or that you do not actually owe the money. Your second move, if the debt is technically accurate but unaffordable, is to file Form SSA 632, which is the request for waiver of overpayment recovery. To win a waiver, you must legally prove two things. First, that the overpayment was entirely without fault on your part, and second, that forcing you to repay the money would defeat the purpose of the Social Security Act by depriving you of income needed for ordinary and necessary living expenses. If you meet these two standards, the government has the legal authority to forgive and wipe out the debt completely. Additionally, you can file a request for change in overpayment recovery rate to negotiate that 50% reduction down to a nominal amount, such as $10 a month, keeping your monthly cash flow intact while the administrative appeal winds its way through the system. This leads us to the third and final change, which is the quietest and most widespread of all three updates landing this July. The federal government is officially rewriting the rules for food assistance under the Supplemental Nutrition Assistance Program, widely known as SNAP or food stamps, in a way that eliminates protections for a specific group of vulnerable older Americans. For decades, federal law attached a strict work requirement to SNAP benefits for younger, able-bodied adults, while older adults approaching retirement were safely exempt from these rules. If you were in your late 50s or early 60s, you could receive nutritional assistance without having to prove to a caseworker that you were actively pounding the pavement looking for employment. That long-standing age exemption is being stripped away. Under the newly implemented federal framework, the maximum age limit for these work requirements has been pushed all the way up to age 64. In practical terms, this means that able-bodied adults without dependents aged 50 through 64 must now officially document at least 80 hours per month of qualifying work, approved job training, or registered volunteer service to keep their food assistance. 80 hours a month breaks down to 20 hours every single week. For a 63-year-old American who may be dealing with chronic health issues, facing age lam fat trong tuyen dung, or acting as an unpaid caregiver for an ailing spouse, securing and maintaining a 20-hour-a-week job is an incredibly heavy burden. Think of a 62-year-old woman who had to step away from the formal workforce to provide round-the-clock care for her husband, suffering from progressive dementia. She is working incredibly hard every day, but because she does not receive a traditional paycheck, the state's automated system will flag her as non-compliant. Unless she files for a specific, documented exemption, her food assistance will be completely cut off. Think tank projections indicate that over 1 million older Americans fall directly into this newly expanded age bracket, and hundreds of thousands risk losing their nutritional benefits, simply because they do not understand how to navigate the new verification rules. The critical takeaway here is that while the age blanket protection has shifted, the underlying legal exemptions for individuals aged 50 to 64 remain firmly on the books. They simply require you to submit proactive documentation to your state SNAP office. You are still legally exempt from the 20-hour work requirement if you can prove you are medically unable to work due to a physical or mental limitation, which can be easily verified with a standard statement from your physician. You are also exempt if you are responsible for the care of an incapacitated household member, or if you are already receiving disability-related income such as supplemental security income or Social Security disability insurance. Once you officially cross the threshold of age 65, you are automatically placed back into the permanent, unconditional exemption category. If you or an older family member relies on SNAP benefits to get through the month, do not wait for a termination letter to arrive. Contact your state's Health and Human Services Department immediately. Request the specific medical or caregiver exemption forms, and have your doctor sign off on the paperwork. The seniors who lose their food security under these new rules are almost never the ones who are unqualified to keep it. They are the ones who qualify completely, but fail to get the administrative paperwork on file before the state's automated deadline triggers a system cutoff. When you pull all three of these major July updates together, a clear and consistent pattern emerges. The student loan garnishment via the Treasury offset program, the aggressive 50% overpayment clawbacks by the Social Security Administration, and the expanded age limits for SNAP work requirements are all designed to execute quietly within the federal bureaucracy. They rely on the momentum of complex regulations and the natural tendency of citizens to overlook the fine print, until the damage is already reflected in a diminished bank account. Houn-hu, as an American citizen, you possess clear, defined legal rights under federal law to contest, alter, or completely block every single one of these actions. For student loan offsets, you have the financial hardship defense. For overpayment notices, you have the 30-day appeal stay and the official waiver process. For SNAP rule changes, you have documented medical and caregiver exemptions. The single most important reality of elder law is that the individuals who get financially hurt by these sudden regulatory shifts are almost never the ones who lacked legal options. They are simply the ones who did not know those legal options existed until their money had already been extracted. Please remember that this analysis is designed strictly for general educational and informational purposes, and it does not constitute formal legal or financial advice tailored to your specific unique situation. Because administrative rules can vary slightly depending on state-level implementation and ongoing federal directives, you should always directly verify your personal file status with the Social Security Administration, the Department of Education, or your local state benefit administration office before filing your paperwork. Now that you understand exactly what mechanisms are launching this month and you possess the precise blueprints to counter them, take a moment to look out for the people around you. Think of one person in your immediate life, a family member, a neighbor, or a friend over the age of 60 who is managing their life on a fixed retirement income, and share this breakdown with them today. One of these three hidden changes could be on the verge of disrupting their financial security, and they almost certainly have not heard a single word about it from the official channels. Taking the time to inform them today could be the exact reason they are able to protect their income and keep their money where it belongs.